Kouri Richins just got an answer she really didn't want. No bail again. Hi y'all, I'm Lawyer Lee, back for an update on the Kouri Richins case. Kouri has been locked up for over 2 years waiting for trial, and this time she came back to court with something dramatic. A key witness changing his story and swearing that the prosecution's version of events was not true. Her team said this wasn't just new, it was game-changing. But the judge did not see it that way. In fact, the ruling suggests that the court believes Kouri Richins is still a danger, still a flight risk, and still facing evidence strong enough to justify keeping her exactly where she is. Instead of opening the door up for Kouri Richins to be released, the judge doubled down, and his reasoning gives us a very clear window into how the court is viewing the strength of the evidence and the risks if it lets Kouri Richins out of jail. So today we're going to talk about what this ruling really means and what it tells us about the road to trial and about the silver lining in this for Kouri Richins. If you're following this case, please hit the like button. It helps more people find these updates. A quick reminder, Kouri Richins is the Utah mom who stands accused of poisoning her own husband, Eric Richins. Prosecutors say her business was in dire need of a financial injection, so she decided to kill her husband, thinking she would get insurance money. And then afterwards, she even wrote a children's book about how she had helped her children deal with the trauma of losing their father. Eric Richins was found dead in the Richins bedroom on March 4th, 2022. Kouri was arrested a little more than a year later. She now has been in jail for more than 2 years, awaiting trial on a number of charges, including the murder of Eric. Bail would not take away the very serious charges against Kouri, but it would mean that instead of preparing for trial inside the jail, she could prepare while she was out of jail. But this week, the court denied Kouri bail for the third time. Now, let's start with why Kouri was asking for bail for the third time, because usually the judge denies bail once and that's it. But Kouri said she had major news that changed everything, and she claimed that one of the state's key witnesses had recanted, meaning had taken back what he had said before. She attached 2 affidavits from him swearing that what he says now is true. Now, that alone would have been very huge news, but the motion said even more. It claimed that the prosecutor knew that the witness had a new and different story and tried to hide that fact from Kouri Richins. So let's break down this brand new evidence from Kouri. So according to the autopsy, Eric, her husband, died because he had 5 times a lethal dose of fentanyl in his system. Prosecutors say they can prove that Kouri bought fentanyl twice shortly before Eric died of the overdose. And they believe Kouri gave Eric the fentanyl that killed him. Now, the state has 2 key witnesses who put the fentanyl into Kouri's hands. And it is one of those witnesses who recanted. So here's the first story, the one told by the state initially. Kouri's housekeeper is named Carmen Lauber. Lauber says Kouri wanted to buy the drug and she asked Lauber to help her. So Lauber found a drug dealer, Robert Crozier, who was selling fentanyl. She met him at a gas station. She bought 15 to 30 pills, which she gave to Kouri. Apparently, Kouri was not entirely satisfied with the product, and she asked for another round of even stronger stuff. So Lauber went back to Crozier and got another round of fentanyl. Initially, Carmen Lauber was set to testify to this, and so was Robert Crozier, who supposedly sold those pills to Carmen Lauber. That makes it a pretty strong point for the prosecution. But note that just because Kouri bought the drug would not mean that she gave it to her husband in order to kill him. But it would at least go a long way to proving she had access to it right around the time her husband died. So these 2 witnesses, Carmen Lauber, Robert Crozier, are critical for the state's theory of the case. But now the testimony of Robert Crozier is in doubt. Here's how it's changing. This is from his affidavit filed with the court. He said, I did not sell Carmen Lauber fentanyl in February of 2022, but sold her 30 milligram OxyContin pills. In early 2022, I was not selling fentanyl and did not have access to fentanyl. Rather, I was selling my own OxyContin prescription, which were 10 milligram pills. If a buyer wanted stronger pills, I had a source who provided 30 milligram OxyContin, which is what I sold to Lauber. Roxy's or Roxy 30s refer to 30 milligram OxyContin pills. To my knowledge, Blues also referred to OxyContin until late 2022 when I came to know the term as being used for fentanyl. I did not acquire a source for fentanyl until the end of 2022. The fentanyl pills that I began selling at that time were very dark blue, almost purple. In April of 2025, I was interviewed by prosecutors with the Summit County Attorney's Office and told them that I had sold OxyContin to Carmen Lauber and not fentanyl. Now, why is this change of testimony so important? It's because of why Eric died. It wasn't from an overdose of OxyContin. It was from an overdose of fentanyl. So let's get back to Kouri's motion, which asks the court to reconsider her bail. Now, Kouri's team brought Crozier's new testimony to the court and to the world's attention in the form of a motion to reconsider bail. They were fighting an uphill battle since the court had already denied bail for Kouri. Now, a year ago, when they applied for bail the second time, Kouri Richins had been in jail for more than 17 months. That whole time, and still she is presumed innocent. And the defense asked the judge to reconsider back then. The defense said Kouri didn't have enough money to go anywhere. She couldn't flee anywhere even if she wanted to, and also that she would never do that because she wouldn't abandon her children. Why not let her out under very strict conditions? But the judge was very clear and gave an adamant no.
She now faces 2 first-degree felonies, each with a minimum sentence of 25 years to life, in which may be run consecutively, one after the other. As before, the severity of these sanctions, put plainly, of potentially dying in prison, creates a powerful incentive for defendant to harm herself or witnesses in this case, and to flee the jurisdiction of the court. And as before, substantial evidence supports the charge that defendant secured fentanyl and deployed it to kill another person, which is inherently dangerous conduct. Moreover, defendant's relationship to her children and her ongoing real estate businesses were, in June 2023, substantial connections to the local community that mitigated the risk that she would flee. But now, in November of 2024, those anchors have been weakened substantially. The juvenile court has granted guardianship of Ms. Richins' children to members of Eric Richins' family, and through that guardianship, they are limiting Ms. Richins' contact with her children, and that circumstance is likely to persist in some form, even if Ms. Richins is released on bail. And there's a reasonable inference based on the evidence admitted at the preliminary hearing that defendant's real estate business is now defunct, and that she would not be able to restart it at any time in the near future given the cloud constituted by this case. So as compared to June 2023, the current circumstances support a finding by clear and convincing evidence that defendant poses a substantial danger to the community and that defendant is likely to flee the jurisdiction if released on bail.
Fast forward to the fall of 2025. Kouri's lawyers used Crozier's change in testimony to ask the judge to reconsider. Here's what they said. Lauber only believes she sold Kouri fentanyl because she believed that is what Crozier gave her. If Robert Crozier did not, in fact, sell fentanyl to Lauber, there can be no credible argument that substantial evidence of guilt exists. If the state cannot place fentanyl in the hands of the defendant, the state has no case. Mr. Crozier's statement doesn't just poke holes in their case, it throws a grenade into the middle of it, leaving them nothing but speculation and conjecture, getting them nowhere near the realm of beyond a reasonable doubt. I was surprised by the state's response to this. The state argued that Robert Crozier didn't know what was in the pills either. Here's what they said. He doesn't know the composition of the pills because, as the defense often notes, they were never tested. He was a low-level street dealer who got the pills from an unidentified source at a time when nearly every pill on the street contained some amount of fentanyl. Mr. Crozier speculates that the pills contained only OxyContin simply because he did not come to know that blues referred to fentanyl until a few months after he sold blues to Miss Lauber. That's a pretty risky argument for the state to make because it may make the jury wonder what other state witnesses can't be trusted. It also doesn't exactly fit with what Robert Crozier said, which was that he was selling his own prescription. So I also don't think that the state is going to be allowed to tell the jury that at the time Kouri bought the pills, what they say here, quote, nearly every pill on the street contains some amount of fentanyl. How would they ever prove that? I mean, what person could come in and testify that they knew that to be true? You can't prove a fact by just announcing generally that, this kind of thing happens all the time. So at best, I would think a witness might know of individuals who bought tainted drugs, but those specific instances almost surely won't come in unless there is some very specific connection to Kouri's case. This response, to me, also misses a key point that I think Kouri's team is going to make. Supposedly, Kouri was asking for fentanyl because she wanted to kill her husband. And if so, it's quite the coincidence that she was given something entirely different and it just happened to be contaminated with the very drug she was trying to buy to kill her husband. So in my opinion, that particular argument by the state wasn't great, but the state did have a much better argument. That's that Robert Crozier's new testimony is just not believable, and the jury is allowed to completely disregard it if they want to. Ultimately, that is the argument that the judge went with. Let's look at what the judge said. He said, Kouri has a constitutional right to bail unless there is substantial evidence to support the charge against her. And he ticked off the state's evidence against Kouri. Evidence showing Eric Richins died of fentanyl ingestion. Evidence showing defendant purchased 15 to 30 pills from Miss Lauber approximately 1 month prior to Eric Richins' death. Sworn testimony from Miss Lauber that she acquired fentanyl pills from a source and handed them to defendant in a hand-to-hand transaction in defendant's driveway. Evidence indicating that defendant's subjective understanding at the time of Eric Richins' death was that she would get a greater share of the marital estate if Eric died during the marriage than if he and defendant divorced. Evidence showing that in the months leading to Eric's death, defendant's personal and business bank accounts were overdrawn. She was making significant recurring debt service payments, and the lines of credit available to her were maxed out. Evidence showing that at the time of his death, Eric's life was insured in a substantial amount, with defendant listed as the beneficiary on the policy. And finally, evidence showing consciousness of guilt, including evidence regarding defendant's internet search history in the aftermath of Eric's death, and evidence regarding the movement and manipulation of defendant's phone that is not consistent with her statements to first responders regarding what she did between discovering Eric dead and calling 911. So the court said this evidence is substantial, and that's the worst news for Kouri, but because that is exactly the evidence the jury is going to hear. The jury is going to hear testimony that the judge has already said he believes is substantial. There was another potential problem lurking for the state out there, but it looks like pretty much nothing is going to come of that. In his affidavit, Robert Crozier said that this past March, he told prosecutors that the original story that they had understood from him was false, that he did not sell the drug to Carmen Lauber, not fentanyl. Kouri's team said this is a huge change in testimony, and the state should have told us about this. We found out about it on our own when we just happened to go interview him in jail. The judge did not draw any conclusions about this, but he did point out the prosecutor doesn't remember it that way. According to the prosecutor, Crozier did say, yes, that he couldn't remember what he said at that first interview, but never said that what he said back in 2023 was wrong. The court makes 3 points, the judge does, as he decides Kouri is not going to get bail. First, he says the jury doesn't have to believe Robert Crozier's news story. Second, the court points out that Crozier is not the only evidence that the state has. And finally, the judge said that Kouri's lawyers were forgetting what exactly the judge is supposed to decide when it comes to bail. Here's what he said. In determining whether the state has shown substantial evidence to support the charge of aggravated murder, the court is not required to determine that a reasonable jury will, would, or is likely to convict defendant. Stated plainly, he says, the standard is whether a reasonable jury could convict defendant of the charge. So the judge is saying that it's entirely possible that a reasonable jury could convict Kouri Richins based on the evidence that the state has. Now, all of that is bad news for Kouri Richins because not only is she stuck in jail, but the court believes there is enough evidence that a jury could convict her. Not necessarily will convict her, but could convict her. But even though the defense did lose that battle, I want to point out something else, something pretty important that they did win. And that's that Crozier's new testimony is, in fact, good for Kouri Richins, and the judge made it clear that the jury is going to hear it. Here's what he said. Defendant may be able to use Mr. Crozier's recent recantation to poke holes in the state's case. Now, this change in testimony, it's not kryptonite. It's not going to defeat the state's case all on its own, but it does hand Kouri Richins a very important argument. Will Kouri Richins be able to beat back the state's charges against her? Subscribe to follow the case with us here on the Lawyer Lee channel, and I'll see you in the next video.